Well, listen, let's go ahead and move on this, because we're all concerned about the question of the issue of personhood, since we're involved in the right to life questions and abortion. But the question of where does the Declaration of Independence, which provides for us much of the understanding that leads to this idea, and the Constitution, how do those fit together? And there's a lot of confusion that's going on in the legal world today. And I listened to some of this and I thought, where did they go to school and what book did they read? But nonetheless, we're going to tackle it. The Declaration of Independence and the United States Constitution serve as two of the three foundational bodies of law for the United States, the third one being the Northwest Ordinance. And by that, if you turn to the U.S. Code Book, you'll find the very beginning of the Code Book, three fundamental laws. There's actually four, but I don't want to go into it. So three foundational organic laws. The Declaration of Independence, the first, which gave rise to the remainder that follows. And what we find is that ideas under the Declaration provide for us the philosophical, if not even theological, orientation that eventually is incorporated into the Constitution, which is a document of process, whereas a declaration is a volume or a doctrine of ideas and philosophy. And there'll be people say, well, the Constitution doesn't have any Christian doctrine in it and theology in it. And that's really true in the most stark way. But that's not true in general. There are some aspects within it that are required to be there based on the kind of document it is, and particularly as it relates to the Declaration of Independence. When you look at the Declaration, you find out that what you have is, what is the role of government? And we're going to go into this more detail, but to put it in real simple terms, the role of government is to secure God-given rights. That is the role. And so often that is not the thing the government is interested in at all. In other words, they're not interested in the question of God-given rights. They always talk about civil rights. If the state gives, the state can take away. On the other hand, the God-given rights of the Declaration are called, and the way they said it, we don't say it that way, but unalienable, which means you cannot take it away. And that makes a difference between a government-given right and a God-given right. So all humans have their rights secured by government, and we'll go more into this in the Declaration in a few minutes. Animals and plants are excluded from these rights. There are no rights for animals. There are no rights for plants or for inanimate things. There are no rights, although you hear people talk about such things. Now, there are responsibilities we have as human beings to creation. I believe in environmental, certainly concerns, but there are no rights out there other than what are given to humans as God-given rights, at least as far as the people who wrote the Declaration were concerned, and I think that's accurate. The purpose of the talk then is to, one, briefly discuss the relationship of the Declaration and the United States Constitution. Two, to set forth the concepts of humanness and personhood within these documents as having an integral relationship that should not be separated. The reason why that we have certain rights, if you want to call them that, is because ultimately our constitutional system builds on the philosophy and theology of the Declaration of Independence. Matter of fact, in a presentation I gave on this particular topic inside the United States Capitol about a year ago to a group, I actually used the word theology, believe it or not, and nobody arrested me. But I said the theology of the Declaration of Independence, because that is in fact what it is. But we'll move more into that. Now, number three, to observe how the United States Supreme Court, particularly in Roe v. Wade, has ignored the clear humanness and personhood of the unborn in favor of specious arguments that promote a preferred public social policy that does not reflect the needs of justice, and we'll talk about that. To critique the decision of Roe in regards to the narrow issue of whether the fetus is a human person in fact, deserving of the rights articulated in the Declaration and the blessings of liberty promised in the United States Constitution. This critique will consider the meaning of human personhood as discovered in the areas of biblical studies, theology, philosophy, jurisprudentially faithful legal interpretation. That's in fact what Gail and I talked about originally. I decided I need 3 more hours to cover all that, so I'm not going to. Unless you want to stay behind, we can discuss. And I can maybe take some questions at the end if time allows. But I've dealt with all these questions that are talked about here but not within a time period I have now. So I'm going to concentrate on the Declaration, Constitution, the issue of humanness, and the issue of personhood. So how does the Declaration of Independence and the United States Constitution relate? This is important. One of the things that became paramount in the confirmation hearings of Justice Thomas is that he continued to talk about the Declaration of Independence. And people said repeatedly in the news, oftentimes they're not very well knowledgeable about issues, they said, he's talking about the Declaration. The Declaration is not a law. It's the Constitution. And I would say, you know, you're not quite accurate on that. It is the first organic law in our code book. And it serves as a foundation to the Constitution, without which the Constitution wouldn't exist. So we have to understand what it is. The reason why people don't like the Declaration, because it sounds too preachy or theological. So it's a preamble to the Constitution. Now I know you have in the Constitution, you open it up, it says, we the people, in order to do this and this and this and this. If you'll notice, it says the idea that to secure a more perfect union, and that's actually what was anticipated by the Declaration, that was not fulfilled in the Articles of Confederation that followed the Declaration of 1776. They had the Articles that didn't make any sense. They went back to the drawing board, created the Constitution, but they both stem back to the Declaration, which is important for our arguments. The Declaration is unarguably a theistic document, not an atheist document. It just doesn't work. When you talk about a creator, laws of God, those things just don't work as an atheistic view. It's a Christian document, arguably a theistic, clearly arguably a Christian. Donald Lund says, after approving the Declaration, the Continental Congress turned to writings of the National Constitution. They mentioned the Articles of Confederation. So then they replaced these articles and they created an American National Compact. Notice, we the people, in order to create a more perfect union. So what we have here is a document that builds on a philosophical argument. The Declaration underpins the Constitution and gives reason for its existence. You don't just start with the Constitution. You have to say why. What is the rationale? What is the basis? What supports this document? And they stated that in the Declaration. Now, if we tried to do this today, that's always bothered me when people talk about a constitutional convention, because the bozos we have today, getting hold of this opportunity would destroy America if we haven't already had a lot of that by other means. So that's another question. But the fact is, the people who did these documents in the 18th century were skilled people intellectually. Look at what they read. Look at what they wrote. Look at how they wrote. Look at their thought patterns. We haven't hardly got a guy in Congress, and I remember reading this from Forrest, what was his name? Forrest, Alabama, university professor of constitutional history. I can't think of his last name. But he said, we do not have the intellectual acumen in our Congress to actually do this again the way they did. And I believe that's the case. I spent a lot of time reading the founders. I taught legal history, not only constitutional law and First Amendment law. And when you read these guys, they're so erudite. And you look at our guys today and you think, duh. And so I'm not impressed with what we have today, by and large. I was actually thinking about running for Congress at one time. I had people pushing me. And I decided not to for the very reason that I thought I would rather give myself to intellectual pursuits than, try to decide water rights and read lengthy bills. It's just so many things consume people today. You can't even read anything. You basically just listen to what people tell you and push the button. So I'm not into that. But the fact is, the people in the 18th century were knowledgeable of history and philosophy and theology and geography and rhetoric and logic and all of these things. They were well-trained, well-educated people. So the first line of evidence that we know this to be the case is, notice the statement, the unanimous declaration of the 13 United States of America. See, the Declaration was the first document of the country, and it actually is what created the United States, not the Constitution. The Declaration created the United States. When that was passed, that is our birthday, July 4th, 1776. Second, the Declaration toward the end concludes this: we therefore, the representatives of the United States of America in General Congress assembled. They saw themselves now as a new country. That's how they viewed it. They thought the 13 states is now a new country. That is the birth of the country. The Constitution written in 1787 then was for the nation already formed in 1776. Again, there was an intervening Articles of Confederation that didn't work. But if you read through these things, and I'm not going to read all this stuff to you, the point of it is that what you observe when you read the document of the Constitution, it assumes repeatedly. It goes back, it goes back, it goes back, in its dating and its figuring of years, all these things, it continues to go back and see the Declaration adds its initiation. And if you read the articles I have here, they're much more detailed, and obviously you can follow it better. But I'm going to stay with my time frame. Notice this here, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to office of president and has been 14 years a resident within the United States. That takes you right back to 1776. Everything in the Constitution presupposes this. It's also interesting to note that the residence requirement went even beyond the date of the Declaration. The term resident was used rather than the term citizen. Because the difference between being a resident and a citizen. There was no such thing as a citizen till the nation was established. That is the adoption of the Declaration. Now, the last indication of the existence of the United States from the time of the Declaration is found at the very end of the Constitution. It says, done in convention by the unanimous consent of the states, not colonies. The states present the 17th day of September of the year of our Lord. My goodness, that sounds religious. Year of our Lord 1787, and the independence of the United States the 12th. See? So it runs back to Constitution, Declaration. You should not separate the documents. How many in school ever really took any time? Well, do you study the Constitution at all in school? Anybody? Do they have classes in civics? Do you actually study the constitutional document?
They study it in the 4th grade
in
Benton County.
Good, 4th grade. That's wonderful. What about the Declaration of Independence? How much is that studied? A little bit? These things fit together. You should study them both. Any of you who are homeschooled, I hope you are doing it, because this is very, very important. The fact is that when I taught law school, and I'm still teaching law, but not at an official law school anymore. I left that to move back to Oregon. But nonetheless, when I did that, it used to be in law school when I was trained, and most of us trained, that you would start out with the decision, what is called Marbury v. Madison, the decision of John Marshall, which started what we call judicial review, which is not a positive in my view, but nonetheless, that starts that off. That's what you read. My first week of law school, when I taught constitutional law, was I had them, and of course I didn't have the same view of the Declaration at that time, so I didn't do it then. But I actually had them to start off the first day of coming prepared to discuss the Constitution itself. Then the next 2 days we read the Federalist Papers and discussed the Federalist Papers. And then the next week I started with the place that most law schools classes start, Marbury v. Madison, because I think it's important to understand the Constitution before you move into the discussion of what judges think about it. Now, so they worked together as a document actually for the proper ordering of society, maintaining morality, civility for the majority of the nation's governmental history. The Declaration sets forth the principles upon which the government of the nation was to be founded, whereas the Constitution establishes the civil powers to be accomplished to accomplish the principles of the Declaration. This perspective gives meaning to the words of John Quincy Adams. Anybody know who that is? What president? Which one? I think it's 6. But I'm open to the correction. But nonetheless, John Quincy Adams was homeschooled, by the way, in case you need to know that. He says, the highest glory of the American Revolution was this. It connected in one indissoluble bond the principles of civil government with the principles of Christianity. He also said, from the day of the Declaration, they, that is to say the American people, were bound by the laws of God, which they all, and by the laws of the gospel, which they nearly all, acknowledge as the rules of their conduct. Now, that was the President of the United States. I'm not sure our President would say that. I'm quite sure he wouldn't. But nonetheless, the fact John Quincy Adams and many of the people that you read from the 18th and 19th century spoke this way and had this perspective about the law, the Declaration, the principles that underlie the government. The government was not just running on its own awry. It actually had a framework in which to operate. And it was guided by the Declaration. I'm going to slip past this here. It's just too much as I'm looking at time. But the fact is, you find that the Declaration of Independence becomes the principles, they say, upon which the Constitution is to operate. Notice this. Each state in the Union, with the exception of Oregon, specifically make reference in their founding documents to either Almighty God, the supreme ruler of the universe, God, Christ, supreme being. Even some in the South have Jesus in the front. All the documents except Oregon do that. I don't know. So what about the meaning of humanness and personhood as understood? The Constitution does not declare when personhood began. The Constitution is a governmental doctrine of organization. It's a processual document. It's not a document of theology or philosophy. It's not intended to be, even though it can't fully escape it. Because some things that it talks about, in view of the way things were in the nation at that time, required them to do certain things. Like the president, see if you can figure out why this is so. The president can actually not have to count Sunday in signing a bill as far as when he must turn the bill back. What goes on Sunday? He gave him, you got the day off there. Even the president doesn't have to sign a bill on Sunday. Let's see. There are many things like that. Questions of oaths, matters relating to many references that are theological in nature, but they're not directly so much as a declaration. There's no direct equation between being human and being a person. Could it be that some humans are persons, some are not, or that some persons are humans, some are not? The fact is, we're going to talk about that. Now, John Marshall, the first Chief Justice of the United States, said that he apologized because some people consume themselves in seeking to demonstrate propositions that everybody else considers axiomatic. What did the Declaration say that was similar to that? Anybody know? Yes, we hold these truths. Can there be such a thing as truth? We hold these truths to be self-evident. You don't have to argue about them. They're axiomatic. Why do I have to argue that the sky is up and the earth is down? Why do I need to argue that? It's axiomatic. It's a given. You don't need to debate certain things. And the people who wrote the Declaration said, we don't have to argue these points, because certain things are self-evident. Now, I could go back and tell you that Locke and John Locke, William Blackstone, many of the people heavily influential on the founders of our country, they actually believe that in that statement that there's a reference to Romans chapter 1 and chapter 2 about general revelation and Paul's teaching, but I won't go into that. Read the book. Now, in some respects then, this is my feeling as I present the evidence that humans and persons are the same in the founding documents of our nation. The framers of the Declaration said the truths of which they spoke were self-evident then. They saw them beyond debate, rooted in the very fabric of the created order, and so is found there. Now, upon looking at pictures of the unborn, all of us have done that. Years ago, in the first book I wrote, actually the second book I wrote, back in sometime back there, actually about 82, I think, or 83. I wrote a book on abortion issues in those days. And I made an argument that there are two things that must be considered, and if they are true, then the debate for abortion ends. And that's back then when it was fairly new for us. And I said, here are the two questions, and they're biblical in nature. First, are you one of us? That's the first question. Because if you're not one of us, if you're not part of what we are, then there's no debate. Who cares? Nobody says you can't get your appendix out. But if you are one of us, then another question enters in. Are you my neighbor? Do I have a duty toward you if you're one of us? And those are the two questions that I have to deal with ethically when I talk about these questions. And you've got to define philosophical and theological foundations before you begin to make decisions about other things. A lot of people work on utilitarianism. If it works, that's all that matters. but I think we have to operate on an ethical standing. So, oftentimes these obviously unborn are viewed as non-persons by our courts. I'm astounded that the arguments even need to be made. Dr. Seuss, who's much smarter than most of our justices, presented an elephant. Did you ever read this one? Yeah. Horace, yeah, it was a great, great story. An elephant who understood that a person is a person no matter how small. Or shall we say sick, crippled, or in some other way incapacitated. Personhood is not defined by utilitarian concerns. You intrinsically are a person or you're not. Well, these are the questions we have to put to people. The Declaration is not merely a propaganda piece, as argued by some to inspire colonists in the war against England. It's a statement, at least in part at its beginning, of first principles. Now I'm going to come at the very end of the talk about the issues of first principles. But if you don't get your first principles down, you never get your life straight. I'm talking about your personal life, or your social life, or any life. Your marriage life. If you don't have some first principles down, established, you have no blueprint. You have no way in which to know how to proceed. You don't know what your purposes are. These are important things. Well, we have our first principles in the Declaration, and people used to understand that long ago. So, the fact is, how would they inform the establishment of government? We hold these truths to be self-evident. That all men, and I'll get to that, ladies, are created equal. That they are endowed by their Creator with certain unalienable, we would probably today say inalienable, but this is based on a Latin thing that we won't get into, rights, that among these are, notice what they say, among these, are life, which then liberty, which presupposes life, and the pursuit of happiness, which presupposes liberty. These build on each other. If you don't have life, you don't have the rest. If you don't have liberty, you don't have the other. But one thing I need to clarify, the fact is, pursuit of happiness doesn't mean that the Declaration of Independence is telling me that God wants in giving me these rights is for me to have a blast. Pursuit of happiness, as that term is used in this period of time, and I've taken the time to read on it, when they said pursuit of happiness, they meant those things that in fact help you to become all that God means you to be, that He's created you for. In other words, you've been able to do things. Pursuit of happiness is to be able to fulfill what you have been made to be. And that's a very positive concept. But it doesn't mean that you have these, what do you think I want to do that makes me happy? But whatever you do that actually makes you better. So they read the Constitution wrongly who believe the Constitution creates any rights. There are no rights created in the Constitution. Okay? We'll talk more about that. What about bills of rights and so forth? The Declaration created the nation, brought into existence the Constitution, which document has as its purpose to limit the power of government from intruding on these natural rights guaranteed in the Declaration given by God. The laws of God have always been above the laws of the nation, any nation. By the way, that statement is not unique to me. Starting recently, Martin Luther King Jr. says that in Birmingham jail. He speaks about that question. Benjamin Franklin said the same thing. John Locke said the same thing. Sir William Blackstone said the same thing. You can just keep on going back through history, even to the point of the period of the 6th century and the Justinian Code. The fact is, God's laws are preeminent even over human laws. And that even goes back to a guy by the name of Peter in Acts chapter 2, if anybody knows about that one. The fact is, that's a principle that God has created us to do certain things, and government has one function, to ensure that those rights that God gave are actually able to be actualized in our lives. That's its function. A second reason I offer in support of the Declaration is the fact it's found alongside the Constitution and the United States Code, which I've already mentioned. What about the meaning of humanness? Now, the problem with this is that there is no differentiation in the terminology in any of these documents that would say something is human and not person, something is person, not human. Human, persons are human. There is no distinction between the two, first of all. Secondly, you've got to get a dictionary that goes back into the 18th century, not Merriam-Webster or whoever else you use, something probably on the internet. You've got to go back and read their dictionaries and what they meant by their terminologies. I've always found it interesting. People use the word, don't use the word baby. Don't use that word baby. Fetus. And I'm saying, yeah, Latin means baby. That's exactly true. They just are ignorant of Latin. We should teach it again. The point of it is, if you know what fetus means, it's a baby and a child. That is it. Okay? So if they want to talk about fetus, okay, it's a baby. And I'm glad they agree with us. So the fact is, we must look at the language at the time, and we're going to look at some of that in just a moment. When we say the word men, I stood in Williamsburg one day with a group, and some young guy, and he was there apologizing profusely for the fact that Jefferson was a sexist because he said all men are created equal, and ladies, we've grown up since then, and that's bad. Except this guy's ignorant of history. Jefferson, when he said men, read the materials, he meant women too. It was a generic, nobody thought anything about it. We've become more conscious of that today. I don't mind if you want to be called whatever you want to be called. But the point of it is, Jefferson meant everybody. And so you have to give him the due consideration for what he means. In the same way, the word fetus, it means the idea of someone who's a baby, a person. Now, when you look at, then, this language, a fetus is a child, and that's what it is, and a child is a person, then a fetus is a person. And that's what they had. These people didn't have to do too much logic to figure this out. Have you been amazed sometimes at how some people seem to be so dense? I was listening to these people out here today on the road. Did you see them? Walking back and forth and back and forth. I thought, well, it's about time they have to get some exercise. But I used to pick it every single week for years. And so these people needed the exercise themselves. I used to just sit back and jeer. Now I can look at them. And the fact is, if they were to do some serious thinking, they would stop some of the things they're saying. The fact is, at the time of the framing of the Constitution, a person is defined as, and these are the dictionary, an individual, a man, a woman, one, anyone, oneself. And at the same time, as the 14th Amendment, back in the late 19th century, is defined as a man, woman, child, a body. During the former period, a child was defined as an infant and very young person, a son or daughter, the descendant of man, however remote, one that is in some respect or other an infant or young person. In the latter period, child was an infant person in his tenderest years, the offspring of a person, the descendant of a man of any age. In the former period, a fetus was a child in the womb, perfectly formed. And the latter signifies a child in the womb after it's perfectly formed. So I'm talking about the difference between what you find in the 18th century, the earlier period, right around the turn of the late 1700s, and what you find at the time that the 14th Amendment was passed at the very end of the 19th century. The fact is, you find that the terminology used, they didn't have a problem with this. But we do. Now, all of this shows that a child is a fetus, a child is a person, thus a fetus is a person. So first of all, as far as that debate goes. Now, when you look at the Pennsylvania Constitution, used by our framers heavily when they worked on their document of the Constitution, it says in part that all men are born equally free and independent and have certain, this is their reading from the Constitution of Pennsylvania, certain natural and inherent and inalienable rights, among which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. That all men are born equally free and independent. Now, all men are created equal. That's something that's significant. Because you notice it didn't say here in the Declaration that all people are born equal. It says they're created equal. And there's a difference in their mind. Because if you read the document, it says, we hold these truths to be self-evident. You know, you've read that. But above that, it says that we have the laws of nature and of nature's God, right? And that became the basis. That is right out of Sir William Blackstone. Guess who was the person that the people were studying law in the 1760s were reading? William Blackstone's Commentaries on the Laws of England. 5 volumes were put out, I believe, between the years of 1760 and 1765. Maybe 4 volumes. I may be wrong on that. 4 or 5 volumes. I got it in my library. I can't remember. But anyway, those were put out in that period of time. This was the same period of time that many of our founders who wrote these documents were studying the law. Volume 1 of Blackstone is a book on law and theology primarily, in which he uses the terminology, the laws of God and the law of nature. That's Blackstonian terminology. He said there are 2 laws. The laws of nature is one. The laws of God, he says, found in Scripture is the other. He said the latter is of more significance than the former. That's Blackstone. This is the book that every single law student read in the 1760s all the way through the end of the 19th century. It's only at Harvard in the very latter portion of the 19th century, a man by the name of Christopher Columbus Langdale, dean at Harvard, moved to what is called positive law and not natural law, in which they started teaching in Harvard that law is made in the decisions of the justices, not in something external. In other words, a repudiation of the Declaration. But until the late 19th century, every law student read Blackstone, without exception. And you took the bar exam with that. Now, so these kind of things are incorporated in the way we deal with law. The self-evident truth comes from the Creator, indicating the founders did not believe that rights are created by the state. Have you found that's what we call civil rights? If the state can give the law or the right, the state can take it back. And so that's a problem. Third, these self-evident truths include life, liberty, and pursuit of happiness. Every created human, which includes the unborn, has a right to life within the meaning of the Declaration. One would conclude from this that personhood is inherent in humanity. Why? Because it's based on being created. I don't think anybody believes it's magic and you just poof into existence. So every individual is created by God, and thus because of that has rights. It's not even discussing that. It's important. They're not discussing the fact that when you're born you receive rights. You receive your rights in the creative process. So you're endowed by God. The government has no right to decide what is a person or define it differently from what was given by God and recognized in the Declaration. All men are created equal. Now here's something that's hard for us to work with. The Declaration of Independence is an aspirational document. Anybody have an idea what I mean by that? Okay. An aspirational document means not everything is as it ought to be, but this is what we're reaching for. This is what we want. We have set in practice those things that will help us to accomplish our goals. But we recognize it is not all done in a day. Like Rome was not built in a day. Neither is relationships built in a day, or rights as recognized by God come about in a day. But this, we have a basis upon which we can move that way. And that's what the Declaration is. We know that it didn't work with slavery. And that's been one of the terrible things on our past. So many of the problems we encounter today is because that we did not deal with slavery like they dealt with it in England. We needed a Wilberforce in the halls of Congress, I guess. Have you ever seen the movie Amazing Grace movie? Well, about Wilberforce, great movie. Wilberforce was a wonderful man who did a lot of good. We needed some people like that. If we could have dealt with slavery like they did and gotten rid of it without the war, life would be different for all of us today. There's been so many cause and effect problems from this. Well, the framers do not imply by the word equal that all humans then are equal in all respects. Born children are fully human and have life and liberty, but do not fully exercise those rights until majority. Slaves and American Indians were fully persons. By the way, when you read the Constitution, it doesn't say slaves are non-persons. They consider them persons, not free persons, but persons. And when it says that they count 2/3, they don't mean that each of the slaves is 2/3 of a person. They mean apportionmentally. In other words, for apportionment, they could say, okay, well, you've got 100, we'll count 2/3. They didn't say you're not a whole person. You're just not a free person. But they understood slaves and Indians to be persons because they would have a hard time working with the concept of humanity apart from that, but they didn't deal with the issue of slavery, which is unfortunate. Lincoln explained that the proposition referred to those differences anchored in nature between human beings and animals. The axiom is beings capable of giving and understanding reasons over a matter of right and wrong deserve to be ruled only with their consent. That's not true of animals. That's what you have. Now, Harry Jaffa, I don't know if you're familiar with him, but he says, no man is by nature the ruler of another man, and the way of God is by nature the ruler of men. And men are by nature the ruler of horses and dogs. And so the point of it is, human beings have no master under God. There's only one master, not another. And of course, Paul deals with that in Philemon quite well. Equality is not relating to equality of traits or talents or matters of servitude, but the inherent nature that humans have as equal rulers over God's creation. Now, what about the meaning of humanness and personhood then in the Constitution and the Declaration? Notice this. This is the Constitution. We the people of the United States, in order to form a more perfect union. What was not a perfect union? Articles of Confederation, very imperfect, had a lot of problems. In order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure, here's the key, secure the blessings of liberty to ourselves and our posterity. I want to stop there a second. If you read the Declaration after it says we hold these truths to be self-evident, life, liberty, and all happiness, and that governments are instituted among men to secure these rights, not to create them, not to come up with them. The government doesn't have to come up with them. They've already been given by God. The function of government is to secure, make sure that God's gifts are retained by the people. Okay? That's the function of government. And when it says here, the purpose of our constitutional document is to secure the blessings of liberty. So there the government is acting out the Declaration when it does that. See how it works? That's what he's talking about here. Do ordain and establish a constitution. But notice, the blessings of liberty given to everyone who's created by the Creator of life, liberty, and pursuit of happiness is to whom? Well, it says it here, it's to ourselves and our posterity. All those people that we give, birth to. All these people that we let's see, how do I say this? And Anyway, the point of it is these people that come from us, generation by generation, through the process of humans, the fact is that's our posterity. They also have the blessings of liberty, which is implicitly indicating the fact of even the unborn. Progeny, yes, that would be good. Now, the clause mentioning the blessings then go to the born as well as the unborn, it would seem to me, in these concepts of posterity. Now, when you look at the word person in the Constitution, this is informative. And there's a distinction between the use of the word person in the Constitution and the use of that in the Bill of Rights under the 14th Amendment. And we'll see a distinction here. Persons in the U.S. Constitution then it doesn't deny human personhood of the unborn. It simply does not deal in those organizational documents the same philosophical ideas that are found in the Declaration. It talks about person again and again, but deals with issues of citizenship, not rights of life. For example, are you a person if you don't have citizenship in the United States? Well, sure. The fact is dealing with here is not dealing with the question of whether you're legitimately a human or a person, but whether you're a citizen. If you're a resident, it's not the same thing as being a citizen either. So we have to look and see what the document's talking about. So when we look at the Constitution, we'll see repeatedly, no person shall be this or that, recognizing the question of personhood. Person here means the same thing as human being. I've always been amazed, and I have that at the very end of this, when I mentioned it. I've read Roe v. Wade so many times, and Boe v. Bolton and all these Bolton and all these things for years. And I just can't imagine how they get to that thinking. I mean, the guy would have gotten a D minus from me. I mean, it's so bad in logic and study. I mean, the guy is a failure as a writer and a scholar. Blackman, or maybe his clerk did it, but he should be fired. I mean, it is terrible. Even those people that are pro-abortion think it's terrible. That's how bad it is. And when you build a whole superstructure on a terribly argued opinion, you can't have anything but problems. And we'll say something about that. But when I read when I read these opinions, I'm thinking, he's not done historical research. He doesn't know enough about medicine. He doesn't know anything about philosophy, and he doesn't know anything about theology. They keep talking about the fact that human life, you don't have human life. Well, it's life. What kind of life? Cat life? What kind of life is it? Usually, what you are, you produce what you are. Humans don't usually produce cats. Right? And cats don't produce humans. You tend to stay in the same area. So the fact is, if he says, well, we don't know when human life begins, I'm thinking, what is there that's alive? If it's not human. Right? And so this is the kind of argumentation we deal with. If it wasn't for the fact that they're not willing to talk about that question, are you one of us? That question, you can't make any progress. Now, I wanted to point this one out to you in Article 1, Section 2, Clause 3. It talks about the whole number of free persons, including those bound to service for a term of years. What is that? Indentured servitude, which was not considered slavery. It's what you call credit cards. You think I'm kidding with you? No, same thing. You go into debt with someone, and then you are bound until you pay off your debt. You can't just do anything. You're bound. Or you go to jail, possibly, or be sued. The point of it is indentured servitude. We have a counterpart today. And this is not slavery. But the fact is, number of free persons, including those bound to service for a term of years, and excluding Indians, not taxed 3/5 of all other persons, which would have been the blacks here probably. And the fact is, he's not saying they're not persons. The fact is how you apportion representation. Now, when we move on through here, the migration and importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed and so forth, not exceeding $10 for each person. Well, see, person and human seems to be the same thing in here repeatedly. In other words, we're talking about the same idea. Now, Clause 5, no person except a natural born person. What is natural born now? I'm teasing with you a little bit on this because there's been a big debate in the last several years on this question. Are you a natural born citizen versus another kind of citizen? Well, we know you can't move here. Yeah. We know you can move here and not be eligible to be president. You have to be natural born, who should not attain the age of 35, so forth and so on. Notice it says you're a resident within the United States, not a citizen. But the fact is, personhood is required for certain things. Now, let me move on here. 14th Amendment. All persons. Now we move to something else. Most of the references to personhood in the Constitution are procedural kinds of things, issues of office, and all those kinds of questions that are governmental functions. 14th Amendment moves to something else altogether. And this builds on, obviously, the problem that occurred with Dred Scott and not the constitutional period. Because Justice Taney and Dred Scott said that the black man could be owned by another person and could not be set free, and essentially deprived him of his legitimacy under the Declaration. So the fact of Section 1 here in the 14th says all persons born are naturalized. Let me ask you, if you're a person and then you're born, does that mean you're a person before you're born, or is that the person after you're born? All persons who are born, yeah, I would think so. so that you have the fact persons are born, or persons are naturalized. You don't become naturalized and become a person anymore. You become born and become a person. You're a person who is born and a person naturalized. And subject to the jurisdiction thereof are citizens of the United States. Notice the difference between citizenship and personhood. No state shall enforce any law which shall abridge the privileges or the enforce. What time did I stop? Am I supposed to stop?
A few more minutes. 2 or 3 minutes.
Okay, well, fine. I'll stop when I need to. You can always buy the book. So you don't deny any person within his jurisdiction equal protection of the law. So personhood then connects to actually all people who can be considered connected to persons or humanity. Actually, the 14th Amendment seeking to guarantee that the African American actually had personhood actually extended it also to all who fit the same qualifications, whether it be impairment or race or sex or any other consideration, because they're all part of the same group, a family, a genus, as it were, which includes the unborn. Now, just one thing here. The fact is that the court, when it dealt with all these areas, flubbed it bad. Blackman went back to Greco-Roman paganism, trying to find something that indicates, well, people once upon a time, several thousand years ago, didn't think this way, as though that has anything to do with what took place in 1973. Then he says, well, the Hippocratic Oath, the only reason why that should be discounted is because Christians liked it. So anything we like can be, kicked out, because that's prejudicial if we like it. Hippocratic Oath was by a pagan centuries before the time of Christ, and since it was such a good idea, Christians liked it. So did Greeks, who weren't. The common law, Sir Edward Coke, spelled C-O-K-E, he said that the common law had Christianity as its cradle. And the fact is that what you find is that the law passed from the Justinian Code in 534 AD all the way up to the time of the University of Bologna in Italy, 1088, all the way into Europe with the common law, and the common law was viewed by everybody, and I could go through a list of people, was considered to be, in fact, based on putting together the biblical concepts with the Roman law. And so all these things come up, and so what has happened is that there has been an abandonment of first principles. I've tried to emphasize some certain things to you. The axiomatic nature of the Declaration. Jefferson and actually Franklin, Jefferson, Roger Sherman, Washington, missing somebody else, worked on the Declaration, not just Jefferson. And they came out with what they believed to be a consensus of how the people of the 18th century who formed our government thought things should be done. First things, primary principles, just like 2 and 2 is 4. And that's what we have to do. I'm really convinced that more and more, in order to be able to solve these problems, we have to push back more on the issue of our founding document of the Declaration of Independence and say more about it. Because that actually is the first law of our country. Books are available. Thank you.